How to avoid probate. So probate is the legal process of transferring assets from a person who died to their beneficiaries or heirs. Beneficiaries are people who inherit assets through a legal document like a will or a trust, and they're specifically named individuals, and they may or may not be related to the person who passed away. We call that person the decedent. Heirs are who are able to inherit under law. So as an example, in Florida, if a person passes away and they have a spouse and that spouse is still alive and their children are now adults and they don't have any children from outside of that marriage, so just with that one spouse, then the spouse would be the heir at law. They would get everything. Alternatively, if a person passes away and their spouse had already passed away or they've been divorced, then their assets go to their children if they have children. If not, it would go up to their parents if they're still alive, then down and across the siblings, and so on and so forth. So basically, when you pass away, there's two sets of individuals that can inherit. One are people you have named in a legal document, like a will or a trust. Those are called your beneficiaries. Or two, people who are determined under law to be able to inherit your assets. So that's a good thing to point out, because if the people who would normally inherit your assets under law are not who you would want to inherit your assets, then you would want to make sure that you get something in place like a will or a trust to name beneficiaries, so specific people who would inherit. There's a few different ways that you can bypass this court process called probate. Probate makes you actually, well, not you, but the person who's going to do the probate in order to get the assets. You have to actually identify all the assets in the estate that are going through the probate. All the information has to be collected on creditors and any claims anyone has against the estate, and all that has to be figured out and paid before the assets can go to the beneficiaries or the heirs. Probate's lengthy, it's often very expensive, so there's much simpler ways to make sure that your assets go where you want them to go and avoid this expensive and often stressful process. So there's a few different ways that I'm going to talk about today, and they are definitely not all created equal. So first and foremost, if you do have joint accounts, this is most common with spouses or partners who've been together for a long time. If they own bank accounts or investment accounts or real estate in both their names jointly, that's the key term. So it has to be as joint tenants or as a married couple if they're married. If these assets are owned jointly or as a married couple, then the survivor automatically owns the assets when the first spouse or partner passes away. There's no need for a probate. However, in this instance, once there is just one person standing, meaning the partner or the spouse passed away, this joint account now becomes an individual account. And if you don't do something to the account at this stage, then a probate will be required when the current owner passes away. So that's joint ownership. Second, you can list beneficiaries or payable on death or transfer on death recipients on all of your accounts. In Florida, you can even do this on your real estate with a ladybird deed. And by listing beneficiaries on your assets, then this means that the beneficiary will inherit that asset outright when you pass away, or whatever's left of the asset. You can usually name one or more beneficiaries, and in many instances, you can name secondary or contingent beneficiaries. But every financial institution is different, so what you're permitted to do with beneficiary designations or payable on death designations will change from financial institution to financial institution. Also, it is good to remember, one, that if the beneficiaries don't all agree, don't get along, maybe aren't all available to sign documents, things can be problematic and get held up. Of course, there's always the issue of the beneficiary who's listed on an account or even a home passes away before the account holder does. In an instant like that, then it can become very problematic because it's as if there's no beneficiary listed at all. Or in the case of a beneficiary ends up having special needs later on in life and maybe needs government assistance like Medicaid and instances like that, then the recipient, if they just inherit outright, they could lose those benefits. So that can also be very problematic. So this is why sometimes beneficiary designations aren't the best. You have to stay on top of them. If a beneficiary passes away or something happens to that beneficiary, then you often have to switch switch gears, change up all of your accounts. So the last method I'm going to talk about is creating what's called a living trust or a living revocable trust. We call it a living trust simply because you're alive when you create it and you actually do tie your assets or connect the assets to the trust while you're alive. And then it's revocable because you can make changes to the trust while you're alive. You can change the terms of the trust. You can change what the trust says. You can change who gets what. You can also move assets in and out of the trust freely, and you maintain control of those assets. Nice things about a revocable trust that aren't possible with straight beneficiary designations is you can actually account for something like a beneficiary passing away before you, and you can say, well, what happened to their share if that happens? Or if a beneficiary does end up being put on government benefits or becomes in a special needs situation, you can actually create a special needs trust within the trust that would make it so they could still inherit the money, but the money is kept by a trustee who can buy things on their behalf. Another thing that's really nice about a trust is unlike just straight beneficiary designations on accounts, within a trust, you do not have to give your beneficiaries all your assets outright, meaning all at once. This isn't possible when you don't have a trust. So if you name a beneficiary on an account or you name a beneficiary on your home, then these assets become property of the beneficiary right away. All the assets, the entire account. There's no way to kind of dole it out over time or to just have them live off the income. These are all things you can do within a trust. So you can give stage distributions, meaning they get a certain percentage when they hit a certain age, then another percentage at another time, and then a final percentage maybe later. Or you can have it set up where you have primary beneficiaries or those listed first who are just living off of the income in the trust, and then you can have beneficiaries who come in after they pass away who also get to take some of the trust assets that are left over. Really, sky's the limit as far as what you can create within a trust. So it makes it really nice because it really can be your design. You're simply stating, and this is really what a trust is, exactly what you want to have happen to your assets. Not only while you're alive, obviously take care of you, but also after you die and exactly how you want it to be. So you maintain complete control of how that is going to go. And you also set up all types of contingencies. So no matter what happens, you're covered. So it really is the gold or the platinum standard, meaning you can do more things with a trust than you can with straight beneficiary designations, which is why it's a good idea. If you're wanting to avoid probate, it's really attractive to always go with the easiest, least expensive option, but it's not always the best choice, especially depending on who your beneficiaries are. Do they get along? Do you have anyone who you want to give to who currently is on government benefits? All these types of questions should be gone over with a qualified estate planning or estate planning and elder law attorney where you live. And if you live in Florida, we would be happy to help with any of your estate planning and trust questions or any questions to do with beneficiaries or probates, anything at all to do with elder law. We are the non-stuffy attorneys. We're at atCAUSE Law Office, and the link is in my bio.